Prophet Ronald Dwayne Whitfield recording in the United States on Sunday morning, January 30th, 2022.
Presiding Judge Rebecca Bright. Executive Assistant May 2nd, 2018. Ronald Dwayne Whitfield. Rachel Johnson. Via email. 314th District Court. Michael Craig. Via email. Bonnie Fitch. Via email. Attached, please find order denying motion to recuse that was signed May 2nd, 2018, in cause number 2017-02559J, in the interest of Caden Lee Whitfield, a child, 314th District Court, Harris County, Texas. CC, District Clerk. Court Administration 2017-02559J. In the interest of in the District Court. Caden Lee Whitfield, Harris County, Texas. A child, 314th Judicial District. Order denying motion to recuse. Upon reviewing a document entitled Letter Regarding Motion from Father, the Honorable John Phillips, in an abundance of caution, has chosen to treat the document as a motion to recuse. Having considered the information, Judge Phillips has declined to recuse himself, and pursuant to Rule 18A, the motion was referred to the undersigned presiding judge of the 11th Administrative Judicial Region of Texas. The court considered the motion to recuse filed by movant, Ronald Dwayne Whitfield, in the above-captioned case, and has concluded that it does not state legally sufficient grounds for recusal. The motion does not comply for the following reasons, and therefore no hearing is necessary. Rule 18A clearly states: must be verified. Must assert one or more of the grounds listed in Rule 18B. Must not be based solely on the judge's ruling in the case, and must state with detail and particularity facts that are within the affiant's personal knowledge, except that facts may be stated on information and belief if the basis for that belief is specifically stated, would be admissible in evidence, and, if proven, would be sufficient to justify recusal or disqualification. B. Time for filing motion. 1. Motion to recuse. A motion to recuse must be filed as soon as practicable after the movant knows of the grounds stated in the motion, and must not be filed after the 10th day before the date set for trial or other hearing unless, before that day, the movant neither knew nor reasonably should have known that the judge whose recusal is sought would preside at the trial or hearing, or that the grounds stated in the motion existed. The motion is not verified. The motion complains mainly of actions by the court that occurred in May of 2017, making the motion untimely. In addition, at the time of the Pro Se filing, Mr. Whitfield was represented by counsel. Under the law, before he is allowed to act Pro Se, the court is obligated to hold a hearing and warn Mr. Whitfield of the dangers and disadvantages of self-representation, so that the record will establish that the defendant knows what he is doing and his choice is made with eyes open. ID at *18, quoting United States v. Proctor, 166 F.3D 396, 402, First Circle 1999, internal quotation marks omitted. The court had not held this required hearing, and therefore the court is under no mandatory duty to accept or consider pleadings filed Pro Se by a party who is represented by counsel. See in Resondly, 990 S. W.2D 361, 362, Texas App, Amarillo 1999 ORIG proceeding. The court orders the motion denied without hearing. The court orders the clerk of the court to transmit a certified copy of this order to Susan Brown, presiding judge. 11th Administrative Judicial Region of Texas 301 North Thompson, Suite 102. Conroe, Texas 77301 fax 936-538-8167. Date signed. Judge presiding.
Second Region, this is Connie. How can I help you?
Hello, Miss Connie. I had a couple of questions. Does Judge Olin Underwood have a court, and do you all have a clerk?
No, no, sir. We're not a court. He's the administrative judge of the Second Region, and we do not have a clerk. We do not have a clerk of court. He is a coordinator.
Okay.
I mean, an assistant, but no clerk.
Okay. Okay then, ma'am. I had a question. I had tried to get a order from Judge Olin Underwood. My name is Ronald Dwayne Whitfield, and do you have any orders from him denying my motion that a judge be recused?
How long ago was this?
This was between 2017 and 2018.
If you'll put a request in writing, have you already put a request in writing?
Well, no, ma'am. I did talk to Judge Underwood once on the phone, but I had received order from you all's address, but it had Judge Susan Brown on it.
What county is this out of?
Harris.
Okay, that's why we do not have Harris County anymore. It's Judge Brown.
Okay, so
In 2017, Harris County was part of our region.
you say 2015?
17.
September 1, and after that time, that's when we got the.
Judge Brown.
And Judge Brown office, I guess, is it in Conroe or Houston?
It's in Houston. Judge Brown is in Houston.
Okay, well, thank you so much, ma'am.
Okay.
All right, bye-bye. So there you have it. That's how God do 'em. God asks questions that he already know the answer to. This order purports to have been signed by a rubber stamp signature by a Judge Susan Brown. It shows to have been made in the 314th District Court in cause number 2017-02-559J in the interest of Caden Lee Whitfield. And it supposedly it orders that the clerk of the court it is hereby ordered that the clerk of the court transmit a copy of this order to Susan Brown, 11th Administrative Judicial Region Judge, to herself. Okay, I end this video. Prophet Ron Dwayne Whitfield recording on Sunday, May 13th of 2018. Hey, Ms. Sprout. Ms. Sprout, my question before I can message. You called me yesterday and said this Mr. Sprout. Hey, Mr. Whitfield. Hey, so I just got your message. You called me yesterday and said this Mr. Sprout. Hey, Ms. Sprout. Ms. Sprout, my question before I can begin to understand what's going on. So, you don't come to court. Ms. Sprout, when I talked to you last time, and I asked you, I said, why did that judge have me put out that court? But you could still come back the next time and know you got to.
Every court is just a court has subject matter jurisdiction. That doesn't mean that the freedom first.
That was way back in the emergency.
That was an emergency, Mr. Brown.
show call or one or the other? Mr. Sprout, that was the first hearing, very important hearing. Is that initial hearing. You know what that is, don't you? Yes. Yeah, initial hearing is for what purpose? It's determined that causes kid. And it also determines what they put in your house without a warrant. Well, I don't think they had a warrant for you. No, they didn't have a warrant. They didn't have an emergency. And if anyone had read the affidavit, and then you look at the court of appeals who have set out affidavits in other courts about the same. You last time you called in, you and my assistant don't talk to you. But if you want another lawyer, I'm going to withdraw. Yes. I'm going to file my motion to withdraw today that you get somebody else. That you didn't want a lawyer from the beginning. So that means you said you was going to represent yourself. But what he did? He appointed you a lawyer, but he just told me to stand by on the side of you in case you had any questions. I told him I don't represent myself. No, because I challenged you. Okay, Mr. Sprout, because something ain't right. When a person challenges a particular jurisdiction, which is what the first thing pleading is instead of following what they call an answer. What I'm saying is you could have filed, you wanted to file. You would still represent yourself. Okay, but Mr. Sprout, you just understand that. You wanted to, in case you had any legal questions you wanted to ask. I didn't need any legal questions. No, I didn't need any legal questions. What I need was, if you don't I just want to withdraw, you can go and represent yourself. Mr. Sprout, this is what I'm trying to be afraid to come to court. Hold on, Mr. Sprout, let me get it out, please. What I'm saying is, you can't be afraid to put you on one time. No, he never had authority to put me out. I know, but you had the right to come back to each and every hearing, and you haven't been to any of them. No, because if you go on YouTube, what did the bailiff say? I know, I haven't got that to say, but the bailiff can't keep you from coming. But you with me out there, when he said that I was just that one thing. No, he said I was held in contempt. You wouldn't have it. That's what he ought to serve you with a document telling you. Mr. Sprout, you're not getting it. Mr. Sprout, you're not naive or green, are you, sir? I'm just saying somebody would have had to serve you with a document. Okay, then, so therefore, but you saw the judge. They didn't give you nothing like that. I was there. They didn't give me no paper. Exactly. So that was what they call a full adversary hearing, right? Right. And I got put out and never got to speak, right? Never had an opportunity to be heard, right? Well, you didn't wait your turn to be speak, yeah. Well, no, it's not such thing. When I challenge jurisdiction, you can't even go any further. Yeah. And then what the last? But I got a better idea. Let's switch it today. Before 5 o'clock, I'm going to file a motion for withdrawal, set it for hearing, and get off your case and let you try to do it yourself. Because you don't want to listen to nobody. No, Mr. Sprout, this is all I'm saying. You don't want to listen to nobody. I'm seeing my phone recording. I don't want to listen. Hold on. What I'm trying to do is correct. Hold on, Mr. Sprout, all I'm trying to do is say this. The first thing I've been trying to do, and I have a right to do, he can't get it. Once I plead the jurisdiction and I record him, telling him you don't have personal jurisdiction, every court, every court has subject matter jurisdiction. That doesn't mean that the pleading first and upon the court. And it doesn't mean that the court has general jurisdiction. But in any event, the first thing we got to talk about is the Fourth Amendment. Yeah, well, Mr. Whitfield, I'm going to let you handle that part. You seem like you're pretty impressed with the law, so I'm going to let you represent yourself. But you can't do it from the internet or by the phone. You have to appear in court. I'm not asking for advice. Okay, let me just say this, that I won't be you go please follow it more, but I just got to get in the record. When the bailiff, there's 3 bailiffs. My phone was his bailiff in that court, we made his order to get him out. When the bailiff tell me you've been held in contempt and he is acting under the direction of that judge, you know what I'm trying to get what I'm saying? No, judge, I don't want your shit. You instructed y'all went in chambers. When the minute you try to speak to try to get his bitch out, I'm not saying you. I'm just saying the judge ain't good, man. He ain't finna jump to no full adversary hearing when he first got to do what they call an initial hearing. Because at the initial hearing, I got my probable cause out there. I made him take me to jail. We don't want, bitch, you gonna take me to jail tonight. 2, you went in my house without a warrant. 2, you don't have no mercy. You don't got no probable cause. You don't have no extension. And it's all over YouTube. And you know what they say to you? They gonna took my child. Not because my child was in any danger of his health safety, but because of a motherfucking concern. Where your concern come from? That's not a ground for violating the Fourth Amendment. And you tell me this judge never held the hearing. He never. Mr. Whitfield. Yes. I'm going to withdraw today, and I'm going to let you represent yourself solely on your own. Well, yeah, once we get this judge, that wouldn't contribute to this campaign no more. You have to come to court. No, I can't go there. I can't go to court. We need to stop it. Please stop it. Please stop it. Please stop it. You come, and you don't have to abide by the rules. Mrs. Brown, you know what the administrative rules are. Talking whenever you want to talk. Wait a minute. That's what the law says. The law says it's your duty. The law says you can interrupt a judge if he is violating your client's right. That's the only time you can interrupt him. That's what the administrative judicial rule, they must say, no, they a fool. That law says you don't interrupt the judge if he's violating your client's right. I'm going, if he's violating the law, objection, Your Honor, this court has no jurisdiction. That's why I got to get the administrative code. You know, the Supreme Court of Texas, they are by statute, Texas Government Code Section 74.024, authorize the Supreme Court, not the Court of Criminal Appeals, to promulgate the rules of the court administration. But I'm just saying, okay, so just for the record, that's fine. That's fine, but that's why he got interrupted. I'm going to let you do it the way you want to do it. I'm going to let you let me know when I get when the motion to be filed has been actually filed. It will be filed today. And presented, but you know, it also has to be presented, you know, on the 3 days it's going to be set for a hearing on the 9th, and the judge will rule on it and grant it and let me out of your case, and then at that point you're on your own. I've been on my own because I never accepted an attorney. He's got to show cause. And that's why you're going to be back where you were. No, I didn't know when I've been back where I was. That's when we put the stage back on May 8th. I wish you the best of luck with it. Thank you, Mr. Cross. I've been once before I go. I wouldn't contribute any more to this campaign because you know what this, when they already filed against him for all this contribution, y'all keep to this corrupt job. Give him $900. Yes, sir. All right, bye. Bye-bye.
Escorting.
We tell you to leave the building. That's what we're telling you at this time.
I do not need it.
If once you walk out this door, you come back, you'll be trespassing.
I'm finna call the FBI.
Oh, whoever you want to, sir.
Okay.
This deal is over with.
And who are you again, Mr.
Deputy
Coleman?
Coleman, badge number 165. Work for the Harris County Sheriff Department.
Why are you in this courtroom?
Because I was asked to be here.
By whom?
By whoever called me.
Okay, you work for the Sheriff of Harris County? And what grounds you putting me out this public building?
Sir, you already attempted court. You already put this squad.
Attempted court.
I had an attorney that I knew nothing about.
I had an attorney I knew nothing about.
Escorting.
We tell you to leave the building. That's what we're telling you at this time.
I do not need it.
If once you walk out this door, you come back, you'll be trespassing.
I'm finna call the FBI.
Oh, whoever you want to, sir.
Okay.
This deal is over with.
And who are you again, Mr.
Deputy
Coleman?
Coleman, badge number 165. Work for the Harris County Sheriff Department.
Why are you in this courtroom?
Because I was asked to be here.
By whom?